If you amend your articles of incorporation, more commonly known as a charter, or you change your bylaws, you amend your bylaws, you need to file a Form 8K with the SEC within 4 business days, unless this is the kind of change that it was up for shareholder approval. It was made part of the disclosure in a proxy statement. Today on Zippy Point. I'm Brock Romanek, and I'm a big fan of yous. So item 503 of Form 8K requires companies to file the 8K if they amend their articles of incorporation or bylaws, unless it was a proposal for an amendment that was disclosed as part of a proxy statement or an information statement ahead of an annual shareholders meeting. What to disclose? The disclosure for these 8Ks is quite simple. The effective date of the amendment and the description of the provision adopted or changed by amendment, including what it had said before, what the bylaws, what the charter had said before. The trigger event. Bylaws are changed all the time. These 8Ks are kind of common. Here's an example of a bylaws change to allow for a virtual annual meeting, very common last year during the pandemic. And here's one for a change in the bylaws to change the company's voting standard to majority voting. This example has the description disclaimer. The foregoing description is qualified in its entirety by reference to the bylaws, a copy of which is attached here too as Exhibit 3.1. That's common to have a qualifier, to have a disclaimer. This example does the disclaimer by incorporating by reference. And charter changes do happen all the time too. Here's one to change the name of a company, which of course resulted in changes in the bylaws too. I have a separate Vid-Guide about what you file with the SEC when you change a company's name. Check that out. And here's a charter change for a reverse stock split and for a name change too, all in one. That's permissible. A Form 8K is not triggered by a mere restatement of your charter or your bylaws, according to this CorpFin staff interpretation, if the restatement is consolidating prior amendments, prior changes, without making any substantive changes to the bylaws or the article. However, the staff interpretation does recommend that the company file the restated articles, the restated bylaws, as an exhibit to its next periodic report. Oddly, even though there is sort of a materiality qualifier in that staff interpretation, there is not a materiality qualifier to item 5.03. There's a lot of examples out there of companies filing certificates of correction as 5.038Ks, certificates of correction. And the matters corrected sometimes are trivial. Here's a trivial one. The par value is being corrected. Par value? What's that anymore? However, there's quite a few certificates of correction out there that aren't trivial. They are not trivial. Here's an example of one where they are fixing a provision to limit director liability. Note that these 8Ks with certificates of correction often are new 8Ks. They're not amendments to the 8Ks already on file that had the provisions that needed to be corrected. But sometimes they are in the form of an amendment to the 8K. And here is an example of that. Note if a change to the charter materially modifies the rights of a registered class of your company's securities, your 8K will also be filed under item 3.03 of Form 8K. Under item 5.03B, if the company changes its fiscal year other than by a vote of shareholders or an amendment to its charter or bylaws, disclosure must include the date of the determination, the date of the new fiscal year, and the form on which the transition report will be filed, the new fiscal year transition report. And I have a separate Vid-Guide about how you change your fiscal year end. The trigger date. The trigger date is when the change is effective. In some states, there's a lag between when you file an amended charter with the state and when it becomes effective. So you can wait until the state's effective date, or you can file the Form 8K before that if you want, so you don't forget to do it, perhaps. Let's talk about the exhibits. So the exhibits for Form 8K get filed under item 9.01 of the form, and then there's a numbering sequence under 9.01 for the various exhibits you file to this particular 8K that you're filing. Instruction 1 of item 5.03 of 8K points you to item 601 of Regulation SK. That's the item in SK that talks about the exhibits for periodic in these current reports. An 8K is a current report. A 10Q and a 10K are a periodic report. Anyways, when you go to item 601 of Regulation SK, you'll see here that exhibits for changes to the articles and changes to the bylaw are deemed to be 3.1 and 3.2 when you include them in the exhibit index within the 8K. This example shows both, so you can see how that's done. You're permitted by item 5.03 to just file the text of the amendment. You don't have to file the entire new bylaws or charter as an exhibit to the Form 8K. But if you choose to do this, just file the text of the amendment, not the entire thing. Then you do have to file the entire thing as amended as an exhibit to your next 10Q or 10K. Or if you happen to file a registration statement before you happen to file one of these periodic reports first, you would include the entire thing as an exhibit to the registration statement. Most companies choose to file their entire amended charter or entirely amended bylaws in the 8K itself rather than wait till the next filing they make so that they don't forget. This makes sense. Up with signatures, Form 8Ks are signed by an officer, just one who's authorized to sign SEC filings on behalf of the company. And then the SEC rules require that a manual signature be retained for a period of 5 years under Rule 302B of Regulation ST. And let me know what you think.